Hello and welcome to this next module. In this module we'll be discussing law, definition of it, the different types of law, as well as a couple foundational definitions for us. Okay, so let's go and get started. Now this definition should not be earth-shattering, should be pretty straightforward. It's just a good textbook definition to get us thinking, give us a foundation for the rest of this module. Principles and regulations established by a government applicable to a people and enforced by the government. Okay, think about this for a second. Just think about a previous module when we discussed Weber's basis of political power. Think about that legal structure and fabric, where law fits into that. Again, this is something we know, pretty straightforward, but it does give us a point, a foundational point before as we move forward. Now, law, 5 types. In a previous module, we discussed power. We said power isn't just power. Power comes in several manifestations. Law is no different. All right? So law, common law, established by past judicial decisions, requires applying precedent. So this, if you think about this for a second, think about some of those court drama shows you've seen in the past, where the attorneys would say, Your Honor, in so-and-so versus so-and-so, the court ruled blank. What are they doing? They're trying to apply or appeal to precedent. Our court systems love consistency, and if they've already ruled on something in the past, it becomes a part of our common law understanding and fabric when we look at law, interpret law, and apply law. Okay? Next, statutory law. This is normally what our knee-jerk thoughts would be when we hear law. Law formally declared in the legislature. So if you think about a state legislative body, Congress, just passing those pieces of legislation. That's normally what we think of. All right. Administrative law. Regulations that have been issued by an administrative agency. All right. So FAA, FCC, TSA, any and all of those federal agencies in the bureaucracy, whatever policies and procedures that they issue, doesn't come from the courts, it doesn't come from Congress, but they still have the effect of law. Now let's just pause here for a second. We've got a couple more to go through, but common, statutory, and administrative. These 3 types loosely equate to the 3 branches of government. Common law, the judicial branch, statutory, legislative branch, administrative, executive branch. All right. Constitutional law, interpretation, application of national or state constitutions. So really this strikes the heart of your Supreme Court case assignment that you'll be doing for this class. But the interpretation, the application. We've been talking about constitutions, this whole class. I mean, this is class in the American Constitution. But the interpretation, application of it. All right. And with your assignments, what you're going to be looking at in particular in the context of a singular case is how that legal issue was held up against the Constitution, how the Constitution was interpreted within the context of that case. All right. Lastly, equity. Provides relief where common or statutory remedies are inadequate. So this is something that the one thing we just think about, the one example, injunctions. So where you have a certain issue that pops up and common or statutory isn't applicable, this is where equity would come into play. All right. So throughout this course thus far, we have hit a couple points where we've discussed some foundational terms. Now is another one of those times. All right. Adversary system. This is very simple but critically important when we think about the judiciary. Judicial process characterized by conflict of 2 or more opposing parties before an impartial third party, the court. So we have to have a real dispute. The courts don't deal in hypotheticals or theoreticals. The courts have to have a real dispute in front of them. Okay, this is where we think of the court as a passive branch. You see there at the end of the definition, a passive branch that must wait for disputes to be brought before them. So the courts can't just go ahead and arbitrarily rule on certain issues outside the context of the case. They just can't do it. That's why it's considered a passive branch. All right. Advisory opinion. An opinion given by a court on a legal issue to an executive branch, legislative branch, or private individual not related to an actual case. This is a can't do it. Okay. If you couple this with the previous definition, just gives you a better understanding of how the courts basically operate. All right. And so, when we talk about an advisory opinion, once in a blue moon, you might get a Supreme Court justice that, I'm not saying they get in hot water, but they definitely are put in a bad light. They might be speaking to a law school or some group about some legal issue that the court hasn't seen yet or heard yet. And so then they start really almost sticking their big toe in this advisory opinion pool. All right. You can't do it. They have to have a real case in front of them. All right. And that's one of those things, even when you see Supreme Court nominees in the Senate, in confirmation, you always hear them receive the question, well, how would you rule in this case? How would you rule in that type of issue? And in many, many, many cases, they'll say, I would apply the rule of law. Well, at some point, just outside looking in, you could say they're skirting the question. Well, yes, they are to some degree, because one thing that a justice should not do is violate this advisory opinion doctrine. That they can't really get into the hypotheticals of what a court would or could or should rule upon. Not until they have the real case in front of them for them to adjudicate. All right. Anyway, this is the end of this module. As always, go back and review it, pause, restart as needed, and we will see you in the next module.